Okay, we'll see 61. That's what we need to see. A, B and C are partners. A, B and C are partners of a partnership firm carrying on the business of construction of apartments. B, who himself was a wholesale dealer of iron bars, was entrusted with the work of selection of iron bars after examining its quality. As a wholesaler, B is well aware of the market condition. Current market price of iron bar for construction is rupees 350 per kilogram. B already had 1000 kg of iron bars in stock, which he had purchased before price hike in the market for 200 per kg. He supplied iron bars to the firm without the firm realizing the purchase cost. Is B liable to pay the firm the extra money he made, or he doesn't have to inform the firm as it is his own business and he has not taken any amount more than current prevailing market of rupees 350? Assume there is no contract between the partners regarding the above. What is the answer? Payal, what is the answer? You wrote yes? He is liable to give back whatever that 150 rupees are. 150 rupees per kg. Why? What is the provision? He made secret profits. That's what you guys wrote. Remember, if you make any, what is a provision? Provision is nothing but whenever a partner makes any money using the firm's transaction or using the firm's name or using the firm's network, or if he does any competing business or any secret profit, in any of these scenarios, you are liable to compensate the firm for whatever is the profit you made. In the given scenario, secret profit also can be written. Also, it is firm's transaction, no? That is, firm had to buy iron rods. In that transaction, he is making profit, which is not allowed. Now see, specifically, we write all the places unless otherwise agreed. To help you is what they have given you this point. Assume that there was no other contract contradictory. That means there was no private contract. So you guys have to assume that whatever was a contract made in our partnership deed, there was no other provision regarding that. So I'll be writing that is my provision. The partner made money using the firm's transaction. Huh?
But that is his own business.
Correct. Now they had to buy iron rods. So partnership firm is buying iron rods. Now who is selling? He is selling that. That means it became the partnership's transaction. So in the partnership transaction, if you are making any money, it is your duty to disclose. That's why we write secret profits are not allowed.
So
It is your private business, correct?
in the case if he is buying for 330 and if he is telling us 350, in that case he can be telling us a secret profit.
No. See, secret profit is what? He made a profit end of the day. That becomes.
If he disclose means he can.
See, the thing is, what you're saying is correct. He is making the business for his thing. That is agreed. He made profit for his business. Agreed. But you made the profit using which transaction? You could have sold it to an outsider. That is nowhere the firm is involved. For that, we are not telling anything. You sold that for the firm. And does the firm know from whom did you buy it? No. So that yesterday also, if you remember, that is what I told you. It's not that I'm not telling you cannot have a business. You can have a business. The only thing you need to do is you need to disclose that to the firm that it is from this transaction we made this much of money. So you're not supposed to make a profit. You can make profit. It is your own business. Agreed. That's why I added the term called secret profit. That you're not supposed to make. Agreed?
If he earlier he bought for 200 per kg and he sold it for 350 per kg. That is the difference amount he made.
150 rupees, he has to give it back to the firm.
If he gave to the firm for the 200 per kg also, it's a secret profit.
Profit only did not made, no. Now the secret profit scenario itself will not come. What was the provision? Whatever profit you made, that you have to give it back to the firm. In this case, I did not make profit only. So if he purchased at 200, if he sold it back at 200 only, then I did not make profit at all. So I need not have to compensate firm for anything.
Sir, if he disclosed and told that I got 200, but I am selling to 350 because it is my own business.
In the case if they have given that I have purchased at 200 it's my own stock, I'm selling it for 350 and partner's approval was taken, then absolutely no problem. You can keep the 150 rupees profit you made. You need not have to give it back to the firm. Why am I saying you have to give back is because you did not disclose. Understood, huh?
There can be use of firm's property here in the provision.
No, we did not use the firm's property, no? See, use of firm's property is now, for example, I'm using this camera and making my own private video. That becomes use of firm's property. Transaction of the firm means we are buying something or we are paying someone something. I'm doing it through me. Then I am making profit out of it. They're telling that is not allowed.
So what if it is here, the market price is 350, so he is selling for 300. He is selling below the market price.
Still he is making profit. His stock is 200. You're saying instead of 150, he's selling it at 100. I mean, instead of 150 profit, you're saying he's selling at 100 rupees profit. Profit only. Yes. So what we are trying to tell is, it is your duty to disclose that you are doing. Why I am telling you this is, try to understand. See, now you know that the firm wants iron rods. Here it is not that you are helping the firm. We are not denying it. The intention is clear. In the name of the firm, you are not supposed to cheat the firm. Now here you know everything. That's why you are questioning. In reality, do you think you will know everything? Do you really know what outsiders are charging for that iron rods? Would you really know? In reality?
Market price has been given.
That's exactly I'm saying. In the question they have given, in reality, what I'm saying is the intention why we have introduced that provision. If the agent is telling, that is, if the partner is telling that this is how you are making the profit, that means what? You are being transparent. If I do not know that, how will you know what is a genuine transaction, what is not a genuine transaction? How would you know? If you actually see, the market price is also told by the partner only, no? How did you get to know market price is 350? That also partner would only have told you. So you look at the reality. That's why they said you cannot make a secret profit. You disclose and do, we are okay. Now my question is, my simple provision, why cannot you tell that it is your stock? Are you scared of something? Or are you hiding anything? Don't you think that is the easiest one? Just to tell and make profit? So the act presumes that when a person is not disclosing, that means he is hiding something. Yes, sir. Hello? This is arising purely out of transaction with the firm. Hence, Mr. B is accountable to the firm for extra profit earned thereby. Okay, yeah. Next one. Mr. A transfer his share in the partnership firm to B. Mr. B felt that the books of accounts was displaying only a small amount as profit in spite of a huge turnover. He wanted to inspect the books of accounts of the firm, arguing that it is his entitlement as a transferee. However, the other partners were of the opinion that Mr. B cannot challenge the books of accounts. As an advisor, have you guys written this?
Yes, sir.
You guys wrote? No, okay. This I think we are going to see this today. That is when the topic is there. I think it came early.
Sir, you can.
But what is the answer is nothing but people remember, whenever in a assignment, whenever there is a transfer of share, the transferee will not have the same right as that of a partner. So I'm just telling the provision for the sake of it, but when the provision comes, I'll explain it to you. But the answer is nothing but people, the transferee will not enjoy the right to inspect the books of accounts, ask for the books of accounts. You cannot interfere in the conduct of the business. That is a provision. So in the given case, whoever is a transferee, B cannot interfere in the business.
We can go to dissolution.
We will see that. For now, I'll not take that particular thing. I'll explain it to you. We have it today. Today, we'll be seeing that particular provision. That time I'll tell you. Clear? Huh?
Actually, all the partners have the right to inspect the book.
Correct. Yesterday also, if you remember, in rights and duties, we wrote in one place in the brackets except transferee. You remember? Rights and duties. When we started unit 3, initially only we would have written C. Brackets, it will be there. In one place, you would have written transferee.
Except the transferee.
Except the transferee. That is his provision.
In the case of ownership.
In the case of a person who can interfere with the books of accounts and all, A transferee can never interfere with the books of accounts. Why and all, I'll tell you the logic today. We have the topic today. Okay, next one. MN partnership firm has two different lines of manufacturing business. One line of business is the manufacturing of Ajinomoto, a popular seasoning and taste enhancer for food. Another line of business is the manufacture of paper plates and cups. One fine day, a law is passed by the government banning Ajinomoto's use in food and to stop its manufacturing, making it an unlawful business because it is injurious to health. Should the firm compulsorily dissolve under the Indian Partnership Act, how will its other line of business be affected? What is the provision? Compulsory dissolution. Under voluntary dissolution, we saw compulsory dissolution. Compulsory dissolution, when will it happen? Whenever all the partners become insolvent or all but one becomes insolvent or happening of any contingency which makes the carrying on of business unlawful. Now, whenever a business has two separate line of businesses, meaning if I'm carrying on more than one business, we saw it, right? General partnership and particular partnership. I explained this in both the scenarios. One during general partnership, when I'm carrying on 2-3 businesses, in the class example we saw was, if at all I'm doing tobacco, if tobacco is coming to an end, if my legal part can continue, then you need not have to dissolve the partnership firm. Whatever is the illegal part, you need to shut down that business. The legal part can continue. In the given case, Ajinomoto will come to an end. Paper plates can continue. Dissolution of partnership, compulsory dissolution. Provision is compulsory dissolution. It can happen whenever all the partners become insolvent or in the case of
It's a happening event making law.
which makes it unlawful. Shravani, after how many days? I saw you in your childhood. Okay, next one. Sohan, Rohan and Jay were partners in a firm. The firm is dealer in office furniture. They have regular dealings with AB and Co. for the supply of furniture for their business. On 30th June 2018, one of the partners, Mr. J, died in a road accident. The firm has ordered AB and Co. to supply the furniture for their business on 25 May 2018 when J was also alive. Now, Sohan and Rohan continue the business in the firm's name after J's death. The firm did not give any notice about J's death to the public or the person dealing with the firm, Measures AB and Co. delivered the furniture to the firm on 25th July 2018. The fact about J's death was known to them at the time of delivery of goods. Afterwards, the firm became insolvent and failed to pay the price of furniture to Measures AB and Co. Now, Measures AB and Co. has filed a case against the firm for recovery of the price of furniture. With reference to the provision of Indian Partnership Act, explain whether J's private estate is also liable for the price of furniture purchased by them. I think even this provision is also not covered. Okay, we have to. This also will come today only. In short, I told you also. Whenever a partner dies, his estate will stop to be liable after the date of death. In the case of insolvent, when will the partner's estate become? When will it stop to be liable? On the day when the court is adjudicating that partner as insolvent. And I told you also, in the case of death or even in the case of sleeping partner, when they are leaving, you need not have to even give public notice. So from the date of the death, their estate is not liable. That's the provision. But I'll tell you when we are explaining the concept, we'll be going in detail. We have both the concepts today only.
But even if they are not issuing notice, the further transaction should take place in the name of firm or else the remaining partners.
So in this case, what is happening? If 3 partners are there, a partner died. Whenever he dies, whoever is continuing, they will be liable. That is, the partnership firm will be liable, not my share. Now let us imagine if the total share of the partnership firm is 10 lakh. In this, if my share is say 3 lakh worth, this will not be liable in that transaction. Only your 7 lakh will be liable and not my 3 lakh. You know what is the tricky part here, which we are yet to see? That is not the scenario. When did they enter into a contract? Contract was entered on, let us imagine, 1st Jan 2026, when the partner was alive. But did the furniture get delivered? That means, was a contract performed? No. Let us imagine he died on 10th Jan 2026. Furniture was delivered on 20th Jan 2026. Now the question is, that furniture is delivered on 20th Jan 2026, but he died on 10th Jan. But the contract to buy the furniture was entered on 1st Jan. So he is the partner who died. Is he liable for this contract?
No, sir. No, sir.
So this is where, I mean, we are yet to see that, it will come today. Remember, on the day of the death, if the contract is not yet done, whatever are the contracts that it is not yet performed on my death, that happens, are done, that's all, people. From here, your liability comes to an end.
Sir, and also they know that he died.
That is also there, but I'll tell you, when will this come to an end? We will see. We'll be seeing it today. So remember, after the date of the death of a partner, any contract which is not yet performed will be coming to an end from that partner's point of view, not the other partners. I'm telling. For this partner, he will be discharged, because that is what we saw, right? One word I said, that is, from the date of the death, he is discharged. So his estate is also discharged. So is he liable? Answer is no. Are the other partners liable? Answer is yes. Okay, last one. Moni and Tony were partners in the firm, Measures Moto and Company. They admitted Sony as a partner in the firm and he is actively engaged in day-to-day activities of the firm. There is a tradition in the firm that all active partners will get a monthly remuneration of 20,000, but no express agreement was there. After admission of Sony in the firm, Moni and Tony were continuing getting salary from the firm, but no salary was given to Sony from the firm. Sony claimed his remuneration, but denied by existing partners by saying that there was no express agreement for that. Whether under the Indian Partnership Act, Sony can claim remuneration from the firm. Is it allowed? Custom. So when can a partner claim remuneration? My provision is, people, if at all my partnership deed provides, if at all the custom provides. Custom means what? In our partnership firm, we have been used to paying the remuneration. If that is there, then I can provide remuneration to the partners. So in this case, Sony will be entitled for remuneration because in the partnership firm, it's a custom to provide the remuneration. That's my provision.
From the date he no.
From the day he claims, yes, he can be entitled for remuneration. Yes.